Everything you've ever typed into ChatGPT or Claude or Gemini can be read out loud in a courtroom. That's not a theory anymore. A federal judge just made it official. In the next 9 minutes, you'll learn what this ruling actually says, why your AI chats were never protected in the first place, and the 5 rules professionals now follow before typing anything sensitive into an AI. Rule number 5 is the one almost everyone gets wrong. Stay for that one.
Here's why this matters to you. 900 million people use ChatGPT every week, and they ask it the questions they used to ask lawyers, doctors, and accountants. Questions like, can I get fired for this? Is this tax move legal? What happens if I break this contract? Every one of those conversations is sitting on a server, and as of this February, prosecutors can use them.
February 2026. The Southern District of New York, United States versus Heppner. Bradley Heppner ran a financial services company as CEO. When federal fraud charges were coming his way, he did what millions of us do every day. He opened an AI chatbot, Claude in his case, and typed out his problem. Honestly, in detail, the way you'd talk to your lawyer. When prosecutors found those documents, his defense made the obvious argument. This is private. This is like talking to your attorney. Attorney-client privilege. Work product. Judge Jed Rakoff, one of the most respected federal judges in America, said no. Twice. First, privilege protects conversations with a lawyer, and an AI is not a lawyer. The judge wrote that this alone disposes of the claim. Second, and this is the part that should get your attention, the AI company's own privacy policy says it collects your inputs, uses them for training, and can hand them to authorities. You agreed to that when you clicked accept. In legal terms, you told your secrets to a third party, and secrets told to a third party aren't secrets anymore. This was the first ruling of its kind in America. It won't be the last. Let me show you what it means in practice.
To understand why the judge ruled this way, you need 30 seconds of law school. Attorney-client privilege exists so you can tell your lawyer the full, ugly truth, and they can actually defend you. But the protection has one fragile condition: confidentiality. Share the same story with your neighbor, your group chat, or a chatbot, and courts can treat the secret as no longer secret. An AI chat isn't a conversation. Legally, it's a document you voluntarily handed to a tech company. And if you think those documents just quietly disappear, in a separate lawsuit, a court has already ordered OpenAI to preserve user conversations, including ones people deleted. In January, OpenAI was ordered to hand a sample of 20 million chats to opposing lawyers. 20 million. So nothing changed in February. The trap was always there. Heppner is just the first person we watched fall into it, on the record.
Now, if you're thinking, I'm not a criminal defendant, this doesn't apply to me, what's coming next is exactly about you. Because the corporate version of this mistake is already costing people their jobs. And the 5 rules at the end apply to every profession, not just law.
Scenario 1. You're a manager. You paste a messy HR situation into ChatGPT, names included, to draft a warning letter. That chat is now a discoverable record with 0 privilege. In a wrongful termination lawsuit, opposing counsel can demand it. Scenario 2. You're an accountant. A client's numbers go into a chatbot to sanity check an aggressive deduction. You may have just created the paper trail an auditor dreams about. Scenario 3. You're a founder. Your unfiled patent idea, your cap table drama, your investor dispute, typed into a free AI tool could surface in litigation years later. And the lawyers watching already know the older cautionary tale. The attorney who let ChatGPT write his brief and cited 6 cases that never existed. Sanctioned, humiliated, worldwide news. That was AI lying to a professional. Heppner is the opposite, a human telling AI the truth. Both ended in the same place, a courtroom. So here's the professional playbook now. Rule 1. Treat every AI chat like an email you CC'd to a stranger. If it would hurt you read aloud in court, it doesn't go in. Rule 2. Anonymize before you paste. Names, amounts, dates, company identifiers, strip them. The pattern of the problem is enough for the AI to help. Rule 3. If you're at a company, use the enterprise tier, not your personal account. This isn't theoretical. When the court ordered OpenAI to preserve everyone's chats, enterprise accounts were explicitly excluded from that order. Free and plus accounts were not. Same tool, completely different legal exposure. Rule 4. For anything genuinely high stakes, run it past a human professional first and let them use AI under their privilege. A lawyer using AI on your case keeps protection. You using AI instead of a lawyer destroys it.
And Rule 5, the one almost everyone gets wrong. Deleting the chat does not save you. A federal court has already forced an AI company to preserve conversations that users deleted by the hundreds of millions, and to hand 20 million of them to lawyers on the other side of a lawsuit. The only conversation that can't be subpoenaed is the one that never existed. Decide before you type, not after. None of this means professionals should avoid AI. It means the winners will be the ones who use it correctly, inside the guardrails. In the next video, I build an AI paralegal that reviews contracts in minutes, the safe way, the way a law firm would actually deploy it. If your work runs on documents and deadlines, that video will save you hours every week. It's right here.